May please, my lord. Lord, I'd like to mention an urgent matter, my lord. The term of the subcontract expires today. The urgent repetition, my lord.
Today,
My lord, unlisted matter. Because today is the last day of the expiry of the subcontract, my lord.
why you have waited till
My lord, this termination
11
was done on 13/3. Then we had made a representation, but there was no reply to the representation. We waited for the reply of the representation, my lord.
what matters? Okay, we'll try.
Obliged.
May please allow it. Lord, I beg to mention item number 19 and 20. So with the consent of other side, Lord, may I pray this matter be taken after view vacations, Lord?
Okay, Mr. R. Dubey, learned counsel for the petitioners, has sought an adjournment of the cases for consideration to come out with the consent of the learned counsel for the respondents. Full stop. As the prayer is made, with the consent of the learned counsel for the respondents, the prayer is allowed, release the cases. Release the cases after the ensuing, after 4 weeks, on a date 2 weeks by the office.
My deeply.
My lord, with consent of the respondents, my lord, I beg to mention item 24, my lord. The reply has been filed, my lord, herein, but then my rejoinder affidavit, my lord, is under preparation. By today or tomorrow, we are filing it, my lord.
Okay.
Can it come after the vacations, my lord?
Who is for the respondent?
Lordship,
Mr. S.S. Roy. Mr. B. Pathak, learned counsel for the petitioner, and Mr. S.S. Roy, learned central government counsel for all the respondents
Yes, your lordship.
are present. First of Mr. Pathak has submitted that rejoinder affidavit is required to be filed on behalf of the petitioner. And for filing the same, he has sought listing of the case after 3 weeks. First of the prayer is allowed. List the case on so and so. Any interim order?
My lord, there's an interim order of 12/2/2026.
The interim order passed earlier on so and so shall continue till the next date of listing.
1305.
Obliged.
May I pray for listing of this matter for withdrawal, lordship, on day after tomorrow. Obliged.
May it please your lordship. Lordship, we have filed an IA in item number 13 for impeachment today morning.
13.
Yes, we have got the filing number. I am praying that the IA may be called for
Okay. 13.
1-3 for impeachment.
Okay.
Obliged.
Lordship, item number 1, 2, 3, 4, 5, and 27 are similar matter. And
1,
2, 1, 2, 3, 4, 5,
3, 4, 5,
and 27.
and
27.
27.
Yes. Lordship.
Yes.
These are similar matter and Standing Council of Election Commission. She is busy in another court. So the matter may be taken after some time.
Okay.
Item number 9 also.
Obliged.
I am the petitioner.
9 also.
9 also.
Okay.
6. May please your lordship, praying for listing a motion matter tomorrow, my lord.
Okay. What is the subject?
Renewal of excise license, my lord.
Huh?
Renewal of excise license, my lord. They have refused to renew excise license.
Okay.
May I please your lordship? I beg to mention item number 6. Kindly adjourn for a day, lordship. Senior is out of station.
When do you want?
After BU vacation.
Okay. On the prayer of Miss
Yes.
K. Das, learned counsel appearing for the petitioner. Matter, the case states adjourned to so and so. Mr. Z. Bokulia, learned junior advocate Assam for the state respondents, who is present, has submitted that he has no objection to appear.
Obliged, lordship.
Give after.
2404. 24th April.
May it please your lordship? Your lordship's permission, I would beg to mention item number 8, your lordship.
Item number 8.
Since my senior is engaged in some other work, your lordship, was today.
You want adjournment?
Yes.
When do you want?
Your lordship next week, your lordship.
Huh?
Your lordship next week.
Okay. On the prayer of Miss
ADAS.
Ada, learned counsel for the petitioner. Release the case on so and so.
7/4,
Constantly लिखी दो.
7th April. Daily list for motion, item number 7. Item 7.
Kindly pass over for time being. Senior counsel, Mr. Didas is.
Noloboto Hiso.
I'm.
Item number 10.
Kindly forward a matter for the time being. The DJDAS is on leg in court number 1%.
Okay.
Supplementary list for motion, item 26.
And I am used by the F.K. Chaudhary, my lord. Please.
No motion. Then
Can it be after some time? And the respondent.
Daily list for impeachment of party, item number 11. Yes, sir. For motion, item number 7.
I'm extremely sorry, my lord. My lord, the petition number 1 is a parent company based in Dubai, my lord. And petition number 2 is a wholly owned subsidiary of petition number 1 and is registered in India now. Now, the experience of the company is the parent company have got the experience. So there are a lot of clauses where how can you participate, joint venture. Experience the parent company had, so we took the experience of the parent company. And accordingly, it is participated. Joint petition has joined, my lord, bidder. Now, my lord, will kindly see the at page 65 is a tender. Is subject is charter of higher number and hydraulic work over unit so and so. Now, the closing date 19 October and technical bid opening date is 19 October. 2 stage, kindly see on Roman 2, single stage 2 bid system. Now, my lord, please mark at page 66, Roman 14, 10% of the amount of performance security, 10% of the annualized total contract value. This is what you have to do it. So I participate, my lord, in the bid process. After the bid process, which was participated, my lord, an LOA has been issued. Please look at page 155. 155. 4/9/2024. Total estimated contract is 302 crores. I don't know if you got it. So and so, response subsequent communication, so and so. Total estimated contract cost is so and so, inclusive of so and so. Now, my lord, which is most important at page 156. 4.0. You will have to furnish performance security for an amount of rupees 9 crores in the form of bank guarantee as per pro forma 7F attached on the tender demand draft cashier so and so electronic fund transfer fixed deposit account all India within 19/9/2024. If the performance security is furnished in the form of bank guarantee, fixed deposit same shall be valid up to 31/10. this security money shall be refunded to you after so and so, so and so. Now, please turn to page 157. This is, my lord, by the bidding company, my lord, 4.0, and subsidiary, this by the subsidiary is a bidding company, my lord. 157 is the parent company. So, Messrs. Norman Oilfield Technology, so and so, they are also directed to furnish an additional performance security of INR 4.5 crores. So, 10%, my lord, that 9 crores, and 4.5 crores has to be furnished by the parent company. So, this is the issue, my lord, which I like to address. What they have done, my lord, by virtue of the impugn order, the parent company has furnished 4.5 crores, my lord. They furnished. But the subsidiary company could not furnish that 9 crores in spite of, I'll show certain document where the parent company was willing to deposit that amount in the bank in India. But there was some restriction in it, so they could not furnish because there is a RBI guideline subsequently has been issued that this type of transaction, because there is a violation, there will be a violation. Earlier it was allowed, subsequently it is not allowed. And how this impugn order has been passed, please see to 247, my lord. Now, what has happened, my lord? Thereafter, I could not pay the performance security of the subsidiary company. 4.5 crores have been deposited by the parent company in the account of the Oil India. But they could not pay. Subsequently decided that what we decided, that performance security, my lord, which was not the 4.5 crores, that was forfeited. And I was allowed to, and I was also put on holiday list. So that is the impugn order as page 247, man. This is the ban. The 247 is impugn order, ban for 1 year, man. At page 21,
So,
811.
this additional performance guarantee of 4.5 crore has been forfeited.
Yes, I have.
And you have been put on holiday list.
Yes, 4.5 crores. Yeah, correct. That's the
Right.
And I prefer an appeal before the authority, my lord,
Huh.
because there is a provision for preferring appeal before the authority. So accordingly, at page 253, I prefer an appeal, my lord. 3rd of December 2025.
Yes.
3rd of December 2025.
Okay, we'll try for early resolution.
I'm sorry, my lord.
We'll try for early resolution.
My lord, only one, I think there is one, what our whole case, your lordship is.
Appeal has been disposed of.
No, it's not. That's the whole point, my lord. We came before this court, and my lord, only point, I think one of the case recent, that is WPC, is passed by this court, 1619 of 2015. Facts may be different, but what has been done in this case, what I am saying, the clause I will not trouble today. There is a clause where you say if you cannot forfeit the performance security. What you can forfeit the bid security. Bid security.
Right.
So that is, please see, my lord, one clause I will show. Thereafter, your lordship will further hear it. Page 68, kindly see, my lord. And your lordship can.
That FCI, yes.
FCI.
Huh.
FCI.
Yes.
Yeah, that's the point, my lord. But your lordship will examine.
Yes, this has to be examined.
Examine.
But that is a different
Yes, fact.
issue.
It's a bit of different, my lord.
Slightly different.
Yes, right. But 68, is 68, kindly see, my lord. Last, my lord, Roman 2, 68, Roman 2, backing out by L1 bidder after issuance of LOA. In case LOA issued is not accepted by L1 bidder or the performance security is not submitted as per the terms of the contract within the time specified in the bid document, the bid security shall be forfeited and the bidder shall be dealt as per banning policy available where.
Yes, whether LOA itself results in formation of the contract or not, that is to be examined.
Yes, correct.
If LOA does not result in formation of contract, then performance security is not to be formated. But that requires some examination.
Your lordship has to hear it.
Sometimes LOI itself is LOA and formation of contract. Sometimes LOI is not formation of contract.
Correct.
Or LOA is not formation of contract.
only
has
what
to be
prayer,
looked into.
they can keep this money 4.5 crores in a fixed deposit, man, so that I can, that is up to the court. I just left to the court.
You'll get
Hands
it.
of the court, I will not say much.
Oil is solvent or solvent
Tomorrow if-
respondent, so no issue about that.
I will not.
Tomorrow if there
They are
is judicial-
solvent respondent at least,
This is not trouble.
at least to the extent of 4.5 crore.
Yes, that's
Ah.
okay.
tomorrow if there is a judicial order for us to return, I can take that undertaking or give that undertaking today.
No, I'm not worried about oil solvent.
I am not worried.
4.5 is always available.
Let's let it be keep.
But when can you, what is the status of the appeal?
Oh, it is not.
Appeal, I don't have the answer. It's pending, I believe.
Pending.
It's pending, I believe, also.
If appeal is decided,
It's dated, I
appeal
think.
can be decided on its own merit. While while we are issuing notice,
Appeal in the holiday, but your lordship will be deciding on this issue about what your lordship has
the
said. now.
appeal,
On a blacklisting two point,
appeals are on which points?
on point of holiday, but the point where they have, my lord, the performance security has been forfeited, that the point lordship has to decide.
Instructions on that aspect. Because the clause that my learned senior has just now shown, it says bid security, but what has fallen from lordship's mouth also, whether the LOA is ultimately a contract has been formed, that instruction I'll take from lordship.
That has to be examined from the
Yes.
recitals used,
Yes,
that's all.
true.
And also the tender document.
Tender document.
Yes, appeal is pending, what to do?
Whereas I'm,
We can dispose it off. If your lordship directs us to dispose it off, it can be
let
disposed
it
of.
be pending. I think pending, it will not be a bar for, then we will take step, it will not be a
That
bar.
will be a parallel.
No, not parallel.
What is the scope of appeal? Let us see the appeal provision. Is there anything in the document?
That is so. That is so. I have left, I have annexed that appeal also. Impugn order is page 247 mile.
247.
Yes. And
It must be there
251.
at the last.
251.
251, second last paragraph.
Then
And now therefore understanding terms of
Desired
strength of banning policy.
my lord will kindly see the wording, if desired, an appeal against this order preferred within 30 days from the date of issue of this order as per.
If you accept this position, then it is all right. If you file an appeal only then, so that is the desire.
Yes.
But you have been informed that there is a provision for appeal.
Yes.
Yes.
Suppose if this is reversed, then everything will be.
Yes. That's correct. The lordship is right.
Mr. Sharma, you can take instruction, then thereafter he has the option also, always, within a time period.
I do not find the appeal in my.
Yeah. 253. 253. 253.
253.
253. 253.
Appeal.
Yes, your lordship. Yes, your lordship. Yes. 3rd of December 2025. It can be disposed of, your lordship. This appeal can be disposed of.
You can take instruction within what time so that
Yes, sir.
they can come back. We can take instruction by the during the course of the day we can dispose of.
Yes, your
Say
lordship.
for maybe election view, 1 month. If you can think that it is possible, then we'll say.
Today, lordship, I'll get the instructions now.
Right?
After 10 minutes, I'll get the instructions.
After some time. No point. Keeping it pending.
Yes, your lordship.
If it is reversed, well and good. Otherwise, we'll take up
Yes.
those issues.
Yes.
If no formation of contract, maybe performance guarantee.
Lordship can pass that order otherwise.
Which
Because no, that directing us to
Okay.
dispose of the appeal. Because as it is under provision of banning policy, under the banning policy, that right is there.
What is the banning policy?
It's
available.
it's not annexed here,
Okay.
but if your lordship will see that order,
I have seen.
it's written there
As per what?
as per clause. As per
Yes,
para
Mr. Das,
Yes.
today is say 31st, 30th April. 30th
First
April.
week of May, lordship may list the matter again and I'll.
No point. No. Why we keep it pending?
Oh, yes,
They should be free.
yes, Lordship, that can be done. But we dispose it of that.
Either this way or that way. If you are not pressing the appeal, that is a different thing.
I just have the instructions, the appeal is yet to be disposed of.
Ha.
So we can dispose it.
Just take an instruction, appeal is disposed of, then okay. Otherwise,
The appeal is not disposed. That's my instruction just now.
with a
Lordship.
definite timeline, we can dispose of. Thereafter, you can have the liberty to file the again. If you are aggrieved
Yes.
after disposal of the appeal, then you have the liberty
Yes, Lordship.
to file appropriate, find out.
No, I just found out, Lordship. I got the instruction.
Okay.
Appeal is yet to be disposed of. It is
Okay.
pending. So
Okay.
Lordship can pass this order.
And whether they will decide on the next point of whether they can withheld that 4.5 crores and forfeited that 4.5 crores.
If
Ground,
they have taken the ground, obviously it can be.
ground we have taken money. So lordships looked at-
240,
Yes, 53.
200, 200, 51.
256 kindly see my lord. 256. I grant.
Exit
I,
and
my lord.
refund. Exit and refund the
So
performance.
oil
factor.
in most terminated restaurant concept, it was only to come therefore and refund the performance and future collaboration considering the opportunity. So it's
What is the forfeiture part?
forfeiture is forfeiture party adjustment, page 68. Page
Not into 51.
68.
Hmm.
It is 68, page 68, forfeiture. Page 68, Roman 2.
No, there is submission of performance guarantee
Yes.
and additional performance guarantee. Now, where is the forfeiture? Decision to
Yes.
forfeit.
Yes.
Is it part of the order dated 8/11/2025?
Not part of it. 201 kindly see, page 201. Lordship got it, 201. Kindly see 202, the last, before the last paragraph. Considering the information and the request received from your parent, message so and so, and your failure to submit the performance security within the stipulated deadline, also the company is in the process of terminating so and so. For this letter is so and so, so and so. Four picture photo. Kindly see next at page 203, my lord. 203. Please note that this letter should be prejudiced to any other rights of so and so and your allied firm parent company, including forfeiture of so and so, is submitted by your parent company at page 203. This amount has not been released. Page 203. Can-
Last paragraph.
Yes.
Without prejudice to any other right of the company,
Yes.
including forfeiture of performance guarantee.
Yes.
Now, where is the
That,
formal order?
yes. They have not released, that's all, my lord. They have not released.
So, there must be a formal order.
My
They
lord,
are threatening, yes, page 202,
yeah,
third line. Moreover, it was also recorded in a meeting in case of failure to meet the above timeline, the performance security amount of rupees 4.5 crore already submitted by your company shall be forfeited.
Hmm.
And action shall be initiated as per provisions of the tender.
Yes.
Right. They are informing that this is likely to happen.
Yes,
Then again, page 203, it is
Yes.
likely to happen
yes.
without prejudice to company's right.
Yes.
Then where is the order, formal order, forfeiting
But,
performance?
but what they have done, formal order has not been passed. But they, in spite of repeated requests has been made to them, they are not releasing that 4.5 crore. They,
Now,
then,
in the absence of any formal order of forfeiting the security, why we will sit upon it?
I'm sorry, my lord.
In absence of any formal order forfeiting the
Yes.
performance guarantee, while we decide, why we should decide on the issue of forfeiture of performance guarantee?
Then what, let them do.
Because the impugn order
Yes,
speaks about banning,
yes.
holiday list.
Yes.
It is silent about performance guarantee.
No, they said in 10.00,
Which part?
it's impugn order.
Please show us.
Then whereas repeated failure to furnished, page 249.
249.
And whereas repeated failure to furnish the performance security despite grant of multiple opportunities so and so, a breach of contractual obligation. Moreover, RBI circular referred to so and so is merely a clarification to existing FEMA regulation, which were all prevailing at the time of submission of bid. Same cannot be considered as a force majeure event. It is settled principle law. The ignorance law is not an excuse. What they have done, my lord, your lordship is correct. Your lordship is right. Your lordship, what they have done, they are threatening that. Yes, I adopt what you're. So they are threatening that. They are threatening that we will not, my lord, will if you don't, we will not refund it, or otherwise this will amount to some action. But they have not taken action. But even in spite, if they have not taken any action, either, my lord, they forfeit this or they refund the amount. They are not refunding the amount. So what to do, my lord? They are not refunding the amount. The prayer, kindly see, my lord. Our prayer we have mentioned. Till today they have not refunded.
Right.
So
They have retained it,
Yeah,
but
correct.
there is no formal order
that
about
is no, but on what
forfeiture of
Yes.
performance guarantee.
Either, my lord, they are right. Your lordship is right. But they have not refunded the amount. They have withheld the amount. They have withheld the amount till today. Kindly see, my lord, our prayer. Also, we have made. What was the prayer? Then 59. Kindly see, my lord, our prayer.
So, without any formal order of performance guarantee, so let them take a decision on performance guarantee also while disposing of the appeal.
I'm sorry, my lord.
They have taken
Correct.
their ground in their appeal. Last paragraph of their appeal, they have taken this ground. We can also therefore deliberate on the aspect, and in the
59.
appeal will take care of that
Paragraph
issue also.
59 also we mentioned in the prayer. Page 59. A retainer nature shall not be issued respondent to refund an amount of so and so so and so.
Right.
At page 59. So let them deliberate on that also.
And then that issue
Yes,
can be
very
deliberated
Order,
also.
and we'll look into all these aspects.
Because there is no formal order.
Yes.
There has to be a formal order.
Maybe there is an order, I don't know, because we are now
No.
perusing the documents.
No, in the impugn order also,
Not
it
recorded.
is silent.
Yes, I have seen that.
I
That-
don't know, my lord. If,
I'm also not 100% sure.
You are conveying the message that this is likely to be forfeited,
Yes.
but you have
The
not
early-
forfeited.
I do not.
my lord, what
that information I do not have.
may not be an appropriate. Maybe they are not refunding. It's amounting to forfeiting.
That we cannot.
No, what I am saying.
No, I have seen many orders of oil or all these
Yes.
PSUs. They makes formal order. Yes, we have forfeited.
Without a formal order, we will not be holding the money
No,
back.
let them.
There has
No,
to be an order.
our whole case. No, my learned friend is there may be some order.
Because
So
I
he
don't
has
have
to
the.
produce that order.
If it is there, we'll produce.
As per our instruction from our client, my instructing lawyer, Mr. Sharma, he said that it has not been communicated to him. Neither he is not aware of it. That's all, right. Otherwise, I would be very happy to come before this court and like your lordship has said, if there's a formal order, I would have challenged that order.
Huh?
My whole grievance is that one aspect is about your putting me on holiday, that too because there is an appeal. So we preferred that. But my only grievance is that you have not refunded. Either you could have, my lord, kindly see the date.
Have you made any prayer for refund?
Yes.
By
In
any application?
application form. We have not filed any application. One second, my lord.
So while disposing of the appeal, we will consider both the aspects and pass speaking order dealing with both the aspects also.
If your lordship looks
So
into,
appellate authority may not decide on the forfeiture of the
Yes, but
performance security because the original authority has not decided on it.
not decided.
How can he decide it?
That's true.
He cannot
I have to know.
assume power on it.
But Oil India as a whole, as an organization,
Right, but
since the appeal is there, and that
No,
aspect
he
has been
cannot,
dealt with.
no, there is some technical issues. When the original authority is not deciding on the performance security, appellate authority cannot decide on it. He can decide only on the aspect of holiday.
On the ban. If they file a representation on this aspect only, that can be also considered.
Let them take a call as regards the performance guarantee.
They can take a call also, Papa, no problem. Let them take.
Heard Mr. D. Das, Learned Senior Counsel, stated by Mr. R. Sharma, Learned Counsel for the petitioners. And Mr. A. Sharma, Learned Standing Counsel, Oil India Limited, for the respond number 125.
125.
Stop. Having regard to the nature of grievance this raised in this petition, petition is taken up for final consideration and the motion stays itself, at the instance of the learned counsel for the parties. So in such view of the matter, and no notice, any notice to the performer respond number 6 is dispensed to it. At this stage, first of para. The respondent, Oil India Limited.
I'm sorry to disturb your lordship at this moment. Your lordship made a query that whether you made a prayer. I just draw your lordship attention to page 197. So it will be easier for your lordship. 197. It starts from 195. That is addressed to chairman at 23rd of January 2025 at page 195.
195,
Yeah.
yes.
195
Any mention?
performance. And if you see at page 197, request for consideration. In the unfortunate event of cancellation letter of award with reference numbers,
Okay.
we respect a request to refund of INR 4 already transferred to Oil India, so and so.
Okay.
So I think my.
By an invitation for bid, IFB number CDZ page 65, CDZ 4364 P24, international competitive bids from competent and experienced contractors were invited through the Oils, OIL apostrophe S, e-procurement site for charter hire of 01 number of hydraulic workover unit within brackets snubbing in Assam and Arunachal Pradesh. Full stop. The type of bidding was online, open, global, e-tender, single stage, there's 2 bid system. Full stop. As per the tender document, the bid security amount was INR 1.47 crores or USD 177,000, and the amount of performance security to be deposited was 10% of annualized total contract value. Full stop. Para. the petitioners have stated that the petition number 1 is a company incorporated under the laws of United Arab Emirates, having its registered office at RAK capital, UAE, and it has gained experience in the field of oil and gas exploration. Post-op. Now, petition number 2 is a subsidiary, wholly owned subsidiary of the petition number 1 company. And the petition number 2 company has its registered office at Gauhati, Assam, India. Post-op. Para. In response to IAB number CDZ 4364P 2024, the parent company along with the subsidiary company participated in the tender process with the experience of the petition number 1 company for qualification in terms of the eligibility criteria laid down in the tender document. Full stop. In the tender process, the petitioners, the bid of the petitioner number 2 company on the basis of the experience of the petition number 1 company was found responsive for the contract work by a letter of award, LOA, dated 4/9/2024, the respondent oil awarded the contract for charter hire of 1 number of hydraulic workover unit stabbing, i.e. brand new unit model 460K HWU is 155 at a total estimated contract cost of INR 302, 27, 99, 540.88 only, inclusive of GST at 12%, as per the cost details tabulated in the LOA. Full stop. One of the conditions laid down in the LOA was that the petitioners, as the LOA holder, would have to submit for performance security for an amount of INR 9.00 in the form of bank guarantee in the prescribed format within 19/9/2024 with validity up to 31/10/2028. Full stop. As the petitioner number 2 company had qualified on the basis of the experience of the petition number 1 company, comma, the petitioners were also required to furnish an additional performance guarantee of INR 4.50 crores, within bracket being 50% of the value of performance security required to be submitted, bracket close, as per the prescribed pro forma provided in the tender document. Within the same time period, with the same validity. Post op. That it is the case of the petitioner that though the petitioners were able to furnish the additional performance security of INR 4.50 within the stipulated time period, comma, they could not,
Extended time.
within, as per satisfaction of the respondent,
Yes.
oil authorities, comma, they, the petitioners, despite their best efforts, could not deposit the performance security for the amount of INR 9.00 crores due to restrictions in transferring foreign exchange imposed by the Reserve Bank of India. Post op. In order to obviate the difficulties faced in submission of the performance security for the amount of rupees, for the amount of INR 9.00 crores, comma, the petitioner also made propositions for alternative propositions, post op. But the respondent oil authorities had insisted for performance security strictly in terms of the letter of award dated 4/9/2024, comma, as conveyed by a letter dated 29/3/2025, wherein a deadline up to 10/3/2025 was given for depositing the performance security amount of INR 9.0 crores, or else, comma, the contract would be terminated without further communication. Post op. It was further conveyed to the petitioners that it was recorded in a meeting of the respondent oil that in case of failure to meet the timeline, comma, the performance security amount of INR 4.50 crores shall be forfeited and actions would be initiated as per the provisions of the tender. Page 202,
Yes.
first para.
Yes.
Full stop. The letter dated 29/3/2025 was followed by an order of termination dated 7/5/2025, whereby the petitioners were conveyed the decision of the respondent oil to terminate the contract with immediate effect. Full stop. It was further conveyed by the order of termination, comma. It was also conveyed to the petitioners that their further actions against the petitioners, including forfeiture of the preference security amount of rupees 4.50 crores, the respondent oil had reserved the rights to take further action against the petitioners, including forfeiture of the preference security amount of INR 4.50 crores. Full stop. After submission of a representation dated 9/7/2025, comma, a show cause notice cum letter of suspension for default came to be served upon the petitioners on 10/7/2025, to which the petitioners responded. Showing reasons as to why the actions proposed in the show cause notice action proposed was not called for. Full stop. Thereafter, comma, an order dated 8/11/2025 has been passed whereby access the competent authority, whereby the petitioners the petition number 2 and all its allied firms, including the petition number 1, have been put on the holiday list of the respondent oil, thereby debarring them from participating against oil's future contracts for a period of 1 year with effect from 10/7/2025. Full stop. The petition number 2 company has, however, been allowed to carry out the jobs for the existing contracts, comma, if any already awarded to it by the oil. Full stop. Apart from full stop. The order dated 8/11/2025 further provided that if the petitioners further provided that the petitioners can prefer an appeal against the order dated 8/11/2025 within a period of 30 days. As per the provisions of the banning policy of the oil. Full stop. Para. Mr. Das Nayan, senior counsel appearing for the petition, has submitted that the impugn order is the order dated 8/11/2025 is limited to the matter of holiday listing. Full stop. The order dated so and so is silent on the aspect of release of the additional performance security amount of INR 4.50 crores deposited by the petitioners in terms of the letter of award dated so and so. Full stop. Though indications were made in the correspondences, in various correspondences of the respondent oil, that an action would be taken with regard to the additional security amount of rupees INR 4.50. Appropriate decision will be taken. Comma, no formal order on the said aspect has been communicated to the petitioners till date.
Yeah.
Full stop. Which page? You said by the petitioners have made a request
Page 190.
to
195.
refund the additional performance security amount of INR 4.50 crores as far back as on 23/1/2025 by its letter of event date. Full stop. But in response, Mr. Sharma led Senegals Oil, appearing for the respondent number 1 to 5, has submitted that as an appeal preferred by the petitioners before the appellate authority on 3/12/2025 is yet to be disposed of, comma, the writ petition at this stage is not to be adjudicated, as the appellate authority would dispose of the appeal so as to enable the appellate authority to dispose of the appeal on its own merits. Full stop. In such view of the matter, comma, the writ petition can be disposed of at this stage with a direction to the appellate authority to dispose of the appeal within a reasonable period of time. Full stop. As no on the aspect of refund or otherwise of the additional security, performance security amount of INR 4.50, comma, if no decision has been taken, no formal decision has been taken on it, comma, the respondent oil authorities would take a formal decision as regards refund or otherwise of the additional security amount of INR 4.50 within full stop, full stop, full stop. Para. Will dispose of. From the fact situation, projected by the parties, it has emerged that an appeal, the appeal preferred by the petitioners against the order dated 8/11/2025 on 3/12/2025 is yet to be disposed of. Full stop. Though correspondences are found to be exchanged between the parties on the subject of, in the matter of additional performance security amount of rupees 4.50 crores, comma, there appears to be no order, no decision, no final decision on it, full stop. Since a period of more than 3 months have elapsed. In the meantime, and the appellate authority is still in season of the appeal, this court is of the considered view that the appellate authority shall consider the appeals in the right earnest so as to dispose of the same as the fate of the petitioners as regards holiday listing, which has cascading effect, is hanging in balance. Full stop. Mr. Sharma, Learned Standing Counsel, Oil, has submitted that a period of 1 month would be sufficient and reasonable and sufficient for the appellate authority to dispose of the appeal. Full stop. You need partial hearing.
Already given.
Huh?
Already given.
He has submitted that the partial hearing has already been given by the appellate authority to the petitioner. Full stop. Taking out.
Not the appellate
taking
authority,
Huh?
not the appellate authority, but the so-cause which is issued.
Okay, not required. It line nalage. Taking the facts and circumstances of the case in its entirety, this court is of a considered view that the repetition is not to be entertained at this stage, as the appellate authority is yet to decide the appeal of the petitioners on its own merits, and no formal decision as regards release or otherwise of the additional performance security amount of INR 4.50 crores has been taken. Full stop. This court therefore deems it fit and proper to dispose of the writ petition with a direction to the respondent oil authorities, more particularly including the appellate authority, to dispose of the writ petition with a direction to the appellate authority to take the appeal on board for consideration and thereafter to dispose of the appeal on its own merits by taking into consideration the regions highlighted by the petitioners in its appeal. The order, the appellate order to be passed is to be communicated to the petitioners. Is to be communicated after passing the appellate order, the same is to be communicated to the petitioners immediately thereafter. Full stop. The respondent, the competent authority in the respondent oil, competent authority in the oil shall also take a decision on the aspect of refund or otherwise of refund or otherwise of the additional performance security amount of rupees 4.50 crores within also within a period of 1 month from today or 30th April.
30th.
On or before 30th. Today is
1 month.
better 30.
But
Fix a time.
termination, my lord, 203, that should be kept open because otherwise it will be barred by res judicata. So your lordship, because they have kept on holiday, that's why, my
Okay.
lord.
On or before 30/04/2025. Another issue which has been raised in this petition is with regard to termination of the contract
203, my lord.
provide or the order dated 7/5/2025. Full stop. As the repetition, as the said repetition has not dealt with, has not dealt with the merits of any of the that or dealt on any of dealt with merits on any of the three aspects, namely the order of termination dated 7/5/2001, 7/5/2025, Roman 2, refund or otherwise of the additional performance security amount of INR so and so, and the holiday listing of the petitioners provide order dated so and so,
8/11,
8/11,
2025.
comma, if it is observed that if the petitioners are aggrieved by the decisions taken by the respondent oil authorities, comma, as directed herein above, comma, would not prejudice the petitioners to seek appropriate remedy on the aforesaid three aspects.
Yes.
Okay. I think that will work.
Yes, Your Lordship.
This order disposes of the repetition.
Obliged, Your Lordship.
Timing matters. Items 1 to 5, item number 9, and items 27.
Item 1.
Lordship, 35 petitioners out of the 6 writ petitions, Lordship, they are eligible.
Now you have to give me
Lordship,
one by one, petition wise.
Lordship, I've got the list.
You have
They've
got the
given
list.
consolidated list, Lordship.
Now tell me how, who are that? They could know, so that they could know and they could go to the polling station on 9th.
Lordship,
Tell me from the first petition.
Lordship, from the first petition,
You tell me. because others could avail the remedy of filing an application.
Lordship, we already filed Lordship before the
But now at this stage, there is statutory bar.
Lordship, our name is in the final electoral roll, my lord.
Let us have the
Lordship, make the
first item number 1.
Lordship, from item number 1, all the names have been deleted.
Huh?
All the names
All the names
have been deleted, Your Lordship.
deleted.
Without any notice, without any hearing, my lord, how can they remove our name, my lord?
Mr. Loskar, I have dealt with the issue already. And there is statutory bar under section 23,
23(3).
right? Nothing can be done from the last date of nomination till the declaration of result. I cannot.
Lordship, our prayer is, my lord, as per my lord, we may be allowed to cast our vote as per.
That is what I have said.
As per.
Have you read the provisions of section 22, 23, 24, and 25 and 26 of the Representation of the People Act 1950? Otherwise, you have to challenge that virus of the act. Special revision was done, rightly or wrongly, right? Your names have been deleted. Now there is a provision which you could have availed. I have directed in 2-3 cases to complete the exercise before the date of nomination. But here, election notification has been published on 16/3. The last date of nomination was 23rd. And the election results is going to be declared on 6th. 4th. Then in between, see section 23. See section 23. The manner in which the other petitions have been disposed of, that the only in that manner that the petition can be disposed of. Now, Ms. Kotogi, tell me,
Lordship,
how many petitioners in item number 1?
none, Lordship.
None. None were in the database or in the electoral roll itself.
The updated one, Lordship. Lordship,
Updated 10/2/2026.
post that, Lordship, there was an eviction, Lordship.
Huh?
They've shifted from the area, Lordship. May see the instruction issued by the DEO, Lordship.
1666.
Second page, Lordship.
One 666. Huh.
As per third para, Lordship, as per the records provided by the ERO, deletion of the petitioner's name from the electoral roll was carried out on the ground that they had permanently shifted from the constituency.
It is their stand, my lord. We are not shifted, my lord.
And we are not fact finding authority. RPH. So on ground C, section 22,
Lordship.
according to you, they have shifted.
Shifted.
Now they have said they are still residing. That these are factual determination. Now, this order has been done by
ERO, Lordship.
electoral registration officer. But he has to decide the application also. Section 23.
Lordship.
It cannot be appealed. First, it is to be determined by him only.
Lordship, there are speaking orders, Lordship.
Speaking order.
Speaking orders for deletion, Lordship.
That is under 22.
Lordship. He's
And
passed
thereafter
those-
23.
Thereafter 23, Lordship.
They have to file application.
Lordship.
Thereafter appeal, first appeal, second appeal.
Lordship.
And that can be done only after
After fourth.
fourth. Notification का sound. In this notification, 6 May as the date before which the election shall be completed.
So after 6th of May.
After 6. Within 15 days.
Lordship.
There is no time limit otherwise.
Lordship.
Preferably within 15 days they can file the application. We can see. এটা simple order আছে, তারপর heard Mr. H.A. Loskar, learned counsel for the petitioners. Miss S. Kotoki, learned standing counsel, Election Commission of India, ECI, for the respondent number
1245.
1245, and Mr. Z. Bokolial, learned junior government advocate, for the respondent number 3. Protected number will be like 5. Para 2, how many? 17. You are a para 2, Para 2, 17 will be here. তারপর 3 নম্বর প্যারাটা লিখো। The petitioners have claimed that some eviction process was carried out.
It was earlier, my lord, not all the petitioner, my lord. Some of the petitioners, my lord.
All petitions are from Pathagandi area.
Yes, my lord, Patagan.
Old Solamona.
No, my lord, different village, there are different village and different polling station, my lord.
Polling station is different,
Different.
but in
Village
area
also
is,
different, my lord.
all are from Sribhumi.
Sribhumi, my lord.
All are from Sribhumi.
Sribhumi, my lord.
Okay, all are from
Sribhumi and same Patargandi constituency.
Pathagandi.
Yes, my lord.
Okay, now Pathagandi is same.
Same.
So, you have prepared these petitions polling station wise.
Polling station wise, my lord.
So, can you mention the police station of different petitions?
Yes, my lord.
Right?
Yes, my lord.
1, 2, 3, 4, 5.
Yes, my lord.
Right? Petition, first one,
Yes,
item
ma'am.
number 1, polling station number so and so.
Yes, my lord.
Can
Yes,
you
ma'am.
give me for our
Uh,
benefit?
In the synopsis, I already stated, my lord, in first paragraph, my lord.
The petitioners have claimed that their
Village
residents
also,
of village, there's old Solamona.
not Solomona, first is my lord. NS, not North South Solomona.
No, Mr.
N of the
I have,
madam.
Mr. Roskor,
Lordship,
come to page 4.
4 minutes.
You have made yourself clear.
Yes,
that,
my lord.
Village old Solamona, I'm saying that only.
No, my lord, the N/S Solomona, my lord. Not old Solomona.
You have read, you have mentioned it. Page 4.
Place 4, my lord.
all are residents of,
Yes, my lord, Old Solomon.
I am looking.
Item number one, my
looking
lord.
only.
Yes, my lord. Item number one, Old Solomon.
Post of, Bol Solamona, Post Office, Kotamoni Bajar, pin 788-728, District Sribhumi, Assam. Post of. The petitioners have stated that for a long period of time, they have been casting their votes in both state legislative assembly elections and stroke or parliamentary elections by virtue of enrollment of their names as voters in the concerned electoral rolls, published from time to time. Most of the petitioners have claimed that they had cast their votes in the previous elections to the state legislative assembly and stroke or parliament as the voters from 125 number Patharkandi Legislative Assembly Constituency, LAC, District Sribhumi, Assam. First, all the petitions who were issued electoral photo identity cards within bracket EPICs by the Election Commission of India, full stop. Para. Mr. Loskar, Learned Counsel, appearing for the petitioners, has submitted that during the process of spatial revision of electoral rolls, 2026. Carried out in the state of Assam, house-to-house verification of voters was carried out, and thereafter a draft electoral roll was published on 27/12/2025, inviting claims and objections from eligible voters. First of, after disposal of the claims and objection on 2/2/2026, the final electoral roll for the year 2026 was published on 10/2/2026 for polling station number 177 under 125 Patharkandi LAC. Post of. He has submitted that the names of the petitioners were duly included, were enlisted in the final electoral roll published on 10/2/2026 in respect of polling station number 177. এর মনে রাখবে polling station সবরে বেলায় বেলায় আছে। Subsequently, full stop. But the petitioners, to their surprise, I have found that their names are not traceable in an official portal maintained by the ECI. Full stop. Agreed by Full stop. Full stop. Absolutely good. Mr. Loskar has submitted that as their names are not included in the electoral rolls, the petitioners would be prevented from exercising right to franchise in the upcoming legislative assembly election in Assam, where a date, 9/4/2026 has been notified as the date of polling. Full stop.
Lordship, our name is included, my lord. Subsequently, it was removed, my lord.
I have recorded. Included, then thereafter, to your surprise, you found that in the official portal it is not there.
Yes, my lord.
I have gone according to your case.
Yes.
I have not put my word there. Lordship. If you have followed, he has further contended that in order to delete the name of a voter whose name was included in the previous electoral roll and also in the electoral roll and also found in the electoral roll dated 10/2/2026, published on 10/2/2026, such a person, so the name of such a person could not have been deleted, and before in the from the electoral roll, and before such deletion, such a person must be given a prior opportunity of being heard. Full stop. But none of the petitioners was afforded any prior opportunity of being heard. Full stop. Para. The petitioners have canvassed that the petitioners are still continuing to reside in the addresses, as recorded in the EPICs and mentioned above. That is within the territorial limits of 125 Patharkandi LAC. And the respondent authorities have acted illegally and arbitrarily to delete the names of the petitioners from the electoral roll. Full stop. Para. When the writ petition was moved on 23/3/2026, the Lions Standing Council, Ms. Kotaki Lions Standing Council, was requested to obtain instruction as to whether the names of the petitioners are enrolled in the official electoral database. First of para. Today, Ms. Kotoki has submitted upon receipt of instructions that the petitioners' names have been deleted. As per the records maintained by the electoral registration officer, comma, the names of the petitioners have been deleted from the electoral roll on the ground that they had permanently shifted from the constituency. MS Kotogi has submitted that ordinarily, comma, prior to deletion of name of a person. You can लिख दियो, para 7 or लिख दियो. Para 7 or लिख दियो. Preferably within a period of 15 days from 6/5/2026. Preferably. Otherwise, there is no time limit. They can file at their own, but preferably so that it can be easily concluded. Okay, this is one.
In item
Then what is the issue? Second
second, 15
item number
item numbers 21680, Lordship.
1680. Same thing.
No, same thing, Lordship. Here, names of 15 petitioners have been re-included.
Included. Where
In-
from? Which instruction?
Lordship, the letter of the
You
DE.
could have prepared it in a better manner.
Lordship, I
You could have-
received it in the
You
morning.
are putting it across.
Lordship, if it's
Tell me 1680 specific.
specific 1680, Lordship, it pertains to polling station 179, Lordship. And in the letter that is given by the ERO, Lordship, 35 names, out of which serial number 1 to 15 pertains to polling station 179, Your Lordship.
1680.
Lordship, there's another.
Another.
Lordship, there's a list of.
Can you?
Lordship, that's the list. 1 to
This one?
15, Lordship. Pertains
these
to
are
polling
serial
station,
number.
Lordship. Pertains to polling station 179, Your Lordship. Third column.
These petitions are from which polling station?
179. Item number 2.
And their serial number?
Lordship, there's a lapse in the thing. Their epic numbers are not mentioned, Lordship.
My name also.
By name,
Petitioners-
Lordship, I can
You
give
can
the
write the
petitioner.
petition number. Yes.
Lordship,
Why should I do all this?
I understand. Lordship, I received it today morning, Lordship. If with your
Yes, Mr. Let us see one by one. Gulai Bibi. Gulai Bibi.
Lordship,
Abdul
1, 2,
Shukur.
1, 2,
Abdul Haq. Then Joina.
Lordship.
Joina 5.
then 6, Your Lordship.
Abdul Kalam Azad. Then Nizamuddin.
7,
7. Rahena.
8,
8.
9.
8. Rahena. Then
Hafsa.
Abza. Then Abida.
Zubair.
Then Zubair. Mansoor.
Lordship. 13.
Sabul.
Hussain.
Sabul.
Then 15, Lordship.
Babul.
Then 16.
Safia. Mojida. Mr. Loskar,
Yes, my lord.
out of 17 petitioners, serial number 4,
Oh, my lord.
And 14.
serial number 4,
Yes, my lord.
and serial number 14,
Yes, my lord.
they have to submit application. Others' name are included,
Yes, ma'am.
right?
Yes, ma'am.
Probably one record. Yet 17, top 17. Polling station
179.
179, polling station number. 17 petitioners. Our IAPA address to Sailovo NS Solamona, Kotamuni Bazar. Yes, sir. When the writ petition was moved, when the writ petition was moved on 23/3/2026, Standing Council was requested to obtain instruction. Today, Ms. Kotoki, a line change over. Has submitted upon receipt of instructions that out of the 17 number of petitioners, save and accept the petition number 4 and the petition number 14. Other petitioners, the remaining 15 number of petitioners, names are included in the electoral roll, and they are in a position to exercise the right to franchise in the general election. Full stop. Insofar the names of the petition number 4 and the petition number 14 are deleted from the electoral roll. Baki is 7 or so far as they are full stop. As the names at a line as the names at a para, as the names of the 15 number of aforementioned 15 number of petitioners are already included in the electoral roll, the said petitioners it cannot be said that the said petitioners have a grievance to agitate. Insofar as the petition number 4 and the petition number 14 are concerned, the aspect of deletion of their names are required to be considered vis-a-vis the provisions of the Representation of the People Act 1950, read with the Representation of People, what is the rule?
Registration of electoral.
Registration of election rules.
96.
Target para 7 of liquidity. I'll come back after 5 minutes. Be ready.
Lordship, in item number 3, Your Lordship, I need some
Fine.
time on it.
This can quote. Item number?
Item number 3, Lordship, 4 petitioners have been included, but there are total 65 petitioners, Lordship.
You need some time.
Lordship. Just to verify, because the names are quite similar, Your Lordship. I verify with the epic numbers. Lordship.
One can.
Tomorrow, Lordship.
Thursday?
Lordship. Item number 4, Lordship.
Just a minute, one by one. Mr. H.L. Oscar and consultant petitioner, Lichidiva S. Kotoki, Agor order to silo sale now. Mr. Amish Kotoki has submitted that she is yet to receive complete instructions in reference to the order dated 23/3/2026 and has sought listing of the case on Thursday. List the case accordingly on Thursday. Item number 4.
2nd April.
Item 4.
Item 4 is similar to item number 1, Your Lordship.
Nobody.
Nobody.
Item number 1, huh? Polling station number
191.
191. Same. Two অলপ difference. দুটাৰ নাম নাই, বাকিবোৰ আছে.
Item number 5, Lordship, same Lordship, nobody.
As one.
Lordship.
All are deleted.
Lordship. Polling station 202.
Polling station 202.
Item number 9, Lordship. It's come up for the
Item-
first time.
Okay. So item number 9. Item number 9 of 23/3/2026 order to silo. Number whole total 5. Oh, not 5.
40.
40. Thursday?
Lordship.
Try
Lordship, sure.
so that they can know that whether they can vote or not.
I'll-
Thursday. 23. 3/2026 order to silo. Polling station number
151. Lordship.
151. Aru nearby address to silo. Jogi Sera, post office Isaville. Aru constituency same, na? Mr.
Same.
Roscoe.
Same.
Lordship, there's another one, item number 27 in the
27. 27.
Your Lordship, 15 petitioners have been included. Lordship.
15. Now how many? 42.
42. 15 are there.
15. In the list it is there.
Lordship, in the list, it's from serial number 21 to 35, Lordship.
Okay, 21. Justin. 21. Itu item number 2 nisna ho. Item number 2 nisna. Yatte naam kira silo ho.
Lordship, I've given a list.
You have given the list. Petition
That-
number 1.
I've given that. It's a handwritten list. That-
Handwritten kiba honde se. Okay. A2. তো বাকি কেইটাৰ ক্ষেত্ৰত item number 2 নিচিনা হ'ব. Polling station 178 address to চাই ল'ব. নামৰ শেষত address to আছে ন. Residence of village.
Page 7, Lordship.
Page 7. NS Solamona. চাই ল'ব. Petition number কেইটা দিয়া আছে. ইয়াৰে WPC number
181.
1813/2026. বুঝছে? এইকেইটা এটা এইটোৰ। এইকেইটা এইটোৰ। বুঝছে? এইখন কাগজ এইটো ভিতৰত আছে। WBC নম্বৰটো লিখা আছে।
Yeah.
That's all?
Lordship. Obliged.
Huh? 309. Oh. 1, 2, 4, 5,
27.
26.
7.
Those are 27. Those are disposal.
Lordship.
The other two on Thursday. No, other, how many?
2, Lordship.
2, Thursday. এইটো লৈ যাব এইফালে এইটো বৰ্তমানে ৰাতিপুৱা কাপোৰ এইখিনি লৈ যাওক এইখিনি কাগজ দিছিলে এইখিনি লৈ যাওক
Daily list, item number 10.
এইটো ডিডছৰ তাতে মই Yes.
May please, your lordship. Lordship, this petition, lordship, is filed by the two local bodies, lordship, two local persons, and they have filed their representation also before the authorities. This is regarding, lordship, a wine shop has been established.
Shifting.
Yes, lordship, shifting. And that is within the radius of a religious place, your lordship.
Yes, Mr. Gogoi.
Lordship, whenever shifting takes place, a public notice, 2025 amended rule.
We have to see the
There's an-
decision-making process.
Yes, even as the inquiry report with me, Your Lordship. An inquiry was conducted.
We'll have to go through the records.
Inquiry was
Lordship.
conducted.
Because we have submitted our applications, they have not given responded to that, lordship.
Because they are not the residents of the 75 meters, Your Lordship. Even a public notice was placed. Submitted the inquiry, even an inquiry was conducted.
Then when I approached the authority, they should have given me the copy of the inquiry, lordship. I approached the authority, lordship, on various dates.
Even a re-inquiry was even conducted. Second inquiry was even conducted, Your Lordship. That's the inquiry report I have submitted.
Bring everything on record then,
Very well, Lordship.
right, Mr. Das?
Yes, lordship.
Then you can respond.
Yes, lordship.
Our inquiry was conducted. You are not satisfied that if, as per the provisions of the act, then we'll decide. Heard Mr. DJ Das, learned counsel for the petitioners. Mr. R.R. Gogoi, learned standing counsel excise department for the responding number 1, 2, 4, 4. Mr. M. Chetia, learned junior government advocate
Lordship, three
Two.
is lordship GS, some lordship.
3.
Three
M. Chetia. M. Chetia, learned junior government advocate Assam for the respond number 3, and Mr. S. Bora, learned standing counsel GMC for the respond number 5. Full stop. The petitioners have stated that their residents of SRS Road and BC Road, comma, Ujan Bazar, Gauhati. Full stop. The petitioner has approached this court stating that agreed by a recent shifting of one Indian made foreign liquor shop, IMFL of shop,
Namely,
owned by the respondent number 6 under a license, comma, which was earlier located at Adabari, Gauhati, to the locality to Bhuvan
to Bhuvan Road,
Borua Road,
Bhuvan Road,
Bhuvan Road,
Zanbazar.
Ujan Bazar, Gauhati. Full stop. According to petitioners, comma, the locality where the MFL offshore has been allowed to shift is in the vicinity, in the restricted radius of, what is the distance you want to say? A restricted radius of 100 meter. 100 meter from Prajapita, Prajapiti or Prajapito? Prajapita.
Prajapati
Prajapati or
Brahma-
Prajapita?
Prajapati,
Prajapati perhaps.
Prajapati.
You said Prajapita.
Prajapati Brahma Kumaris.
Brahma Kumari cannot be Pita. Prajapati. Brahma Kumaris Ishwar or Ishwarya Vishwavidyalaya and a kindergarten school located on the same road, that is Bhuvan Road, Postop. It is the further grievance of the petitioner that no public hearing, no proper public hearing took place prior to the decision to shift the IMFL of SOP in a locality. Postop. In terms of the provisions contained in Assam Excise Act 2000 and Assam Excise Rules 2016, more particularly, Rule 294 A, B, A and B and 289, 289 and 294
And 294A.
and Rule 294A. Postop. When the matter was represented, when the matter was objected to, when the matter of shifting was objected to by way of a representation, the respondent authorities, the petitioners have stated that when the matter matter of shifting was objected to by way of a representation, the respondent authorities did not give any heed to it. Full stop. Issue notice. Mr. Gogoi, Standing Council Excise Department, has submitted that before the decision to shift the IMFL SOP, proper hearing, proper notice, and proper hearing took place.
Even an inquiry was conducted.
As per the provisions of the Assam Excise Act and Assam Excise Rules. And it is only after submission of a due inquiry report, an inquiry report, the decision to shift the IMFL SOP has been taken. Issue notice returnable on so and so. As Mr. So and so appeared accepted. No formal notice. Extra copies 2 working days. The petitioner shall take steps for service of notice and the respondent was 6 by speed post within 2 working days. Where the respondent authorities shall file their response on or before the returnable date. Post of the Land Standing Council. Excise Department shall also obtain the relevant records leading to the decision of shifting of the concerned IMFL SOP.
Much obliged, Lord. 1305. Supplementary list, item number 26.
Speaking order.
I'm sorry, Madam, I was not present when the
Yes,
matter was
yes.
called.
Your worship, I heard the matter. The other day, your worship was inclined to set aside the impugned order, but my learned friend was not present.
Yes.
Yes, worship.
The order
Order is at page 79.
79, their prayer is their extension, Lordship. But their Lordship kindly go through their, this is Lordship. This settlement order.
No, we are more concerned with page 70.
79.
4. Para 8.
70?
4.
That is the order
Para
from the
8.
Honorable Court earlier.
4th line.
Fourth line.
By passing a speaking order.
Yes.
So turn to page 79.
Yes, here, Lordship, this is a law, Lordship. Here, I meant to say here, in person Honorable High Court order, last order, is represented.
Para 3.
It is decided to reject the prayer of Sri Gopal Sarkar, stated in the representation dated so and so for extension of Doloni bill for another 2 years, and hereby rejected his prayer, considering the potential adverse impact on revenue of the corporation. It is not tenable in law. I am sticking to the last part, Lordship, tenable in law. Because it is not, I agree with the Lordship that in the order, it is not reflected fully in the order, but it is not
If there is bar, if
It is not-
there is bar, okay, there is.
It is not being stated, Lordship. My learned friend is also telling in many of the cases, Lordship. Here, Lordship, can you go through this judgment, full bench judgment, Lordship, first, and later on I will Lordship, another judgment of the this court, Lordship, where duta দিল এটা মোক দিটো দুটা দিলো no pass no pass no yes Lord I get up long yes Lordship Lordship can turn into last page, Lordship. Last page, point number 5, Lordship. During the course of hearing, copies of the resolution adopted in the meeting were produced before us, and the resolution provided that settlement is to be made for a period ranging from 5 to 10 years, and it should be by way of tender only, and that to the highest bidder, Lordship. Here, Lordship, in this matter, we invited NIT for 7 years. Then in the initial settlement order, we gave it for 6 years. Stating that after 6 years, it will be considered. We have given another 1 year extension, fully 7 years if they have completed. We cannot give them more than 7 years, Lordship, because in the NIT, we have stated that 7 years.
No, read 4 also. Read 4 also. You have read 5.
Yes, as the FGC has been found to have powers to make settlement in respect of fisheries vested with them, they have implied power to pass orders regarding extension of the settlement. We may, however, like to add here that the extension of fisheries creates unnecessary problems, and as such definite criteria and parameter may be laid down, and some alternative may be found to give relief to that. Here, Lordship, for that reason, Lordship.
Take a decision or recording reasons.
Yes, they have not recorded, but
recording reasons.
Here, Lordship, for extension, Lordship, we have to go by the agreement, Lordship. Agreement part is.
Yes.
Yes.
No, I am not saying that you have to extend it.
That's it.
But for that, you record reasons. This court has directed that pass a speaking order.
Yes, Lordship. Here, they have not passed the speaking.
That is all.
Yeah.
We are neither, you can consider for non-extension or extension, or you may consider for return of some amount or remission. That is up to you. Or may reject the prayer, both the prayer, we don't know. But it has to be some regions. It has to be with some region, because
Lordship,
this court has directed
in that case, Lordship,
that pass a speaking order.
Yes, that order is not speaking order, that I agree, Lordship.
So that is all. So that is all.
Lordship, one part is here they have stated that tenable in law. I am sticking to that. It is not tenable in law. Their prayer of extension is not tenable in law. That is
tenable in law. Why tenable in law?
Lord, that is another part, Lordship.
And what adverse impact it will bring? Definitely,
Lordship, no, Lordship.
after 7 years, definitely the revenue
Hmm.
it will garner will be more.
Lordship.
But make it explicit.
Yes, that should have been in white enabling law.
No, this court has passed the order saying that pass a speaking order. Whether that this order fulfills that.
Criteria.
That is the only concern.
Yes, so here, Lordship, this another order is also Lordship. Lordship may said as I will pass speaking order. I will be doing that.
Pass a speaking order.
My lord,
And the decision of the NIT after passing the order, the subsequent order of finalizing the tender process will abide by it.
Lordship.
Abide by it. That's all.
Lordship. Okay.
my lord, now because of the my lord change situation, this my lord, the restrictions because of the elections, my lord, they will not be able to my lord finalize the.
Or not into
tender.
it.
No, my lord, I your lordship.
Court's order, I think, don't court's order, I don't think. Judicial
No,
order.
we can pass a
Is
speaking
it part of the court?
No, my lord, they'll pass.
Comes within the purview of code
speaking
of.
order, pass a speaking order, my lord. That is all right, my lord. But regarding the settlement, because my lord, I have got genuine grounds why my lord. need
I will
extension.
say the order in respect of the final order for settlement, in respect of the tender process initiated by the face NIT, will abide by the decision will abide by the speaking order. That's all. Something is inherent, it is inherent. I'll not make it explicit.
Now, what I mean to say is, my lord,
I have understood your problem.
Because, my lord, since this period, they will not be earning any revenue, my lord.
So they may have the discretion to allow you.
That may be
No, that is, in the meantime, they will allow.
That may be
They might allow you.
Okay, Lordship, I will incorporate the honorable court's order also. Another order is also there. We cannot grant Lordships. That we cannot grant without because of beyond the NIT Lordship. This order is also there.
Then why you are giving me the full bench? I did not know it earlier.
This one also.
I forgot it. Paragraph 4. Now can a single judge sit over full bench?
No, this is single.
This has been observed.
In fact, my lord, pursuant to full bench.
This AFDC has power to pass order regarding extension of the settlement. This is full bench order.
Yes, Lordship, yes.
Right.
And full bench also said, my lord, you you publish the guidelines that they have not done, my lord, till now. They don't.
No, we always abide by the NIT. NIT we have.
By the NIT, refer to the NIT
Yes,
and the lease agreement, and then say, but otherwise you have a power. Full bench has recognized it.
No, not extension. Beyond NIT.
Now, what does it say then?
Then Lordship goes.
Read again.
Goes Lordship.
Read the full bench judgment again.
Lordship, para 5, Lordship.
No, before that, para 4.
Para 5 is also important because.
That is 5 to 10. So beyond 7.
No, during the course of hearing, copies of the resolution adopted by FDC in meeting so and so were produced before, and the said resolution provided that settlement is to be made for a period ranging from so and so. It should be by way of tender only. So we cannot give extension at any point of time, Lordship. And it is being asserted is.
I have not entered into merits.
Lordship,
I have simply.
Lordship, we will pass it.
In the previous order, I have simply.
Yes, that is a mistake, Lordship. Yes.
Mentioned what they have hesitated.
Yes, Lordship.
I have not recorded my view there.
We will incorporate every.
We are only on the speaking order. That's all.
Yes, we will.
And this full bench also says you have power. Power to reject also.
Lordship.
Power to extend also. Power to reject also.
Yes, Lordship.
I am not saying it explicitly, but because it is his discretion.
Yes, but
your discretion. But you have to take into account his grievance at least. And to find out whether there can be means to redress that. That's all. And the process which have been initiated by the NIT will abide by the. And in the meantime, MDC.
In any way, Lordship, we will pass a speaking order. In any way, we are not giving settlement as per my learned friend is.
In the meantime, you make your arrangement how to operate the fishery.
We are being
How to
advised.
operate the fishery?
No, in the meantime, we cannot operate, Lordship. This is also being settled in another judgment, Lordship, that we cannot give anybody to anybody, Lordship.
We don't know.
That's it.
It is your fishery.
Then also we cannot give without tender, anything. We have to keep hush. There's a specific order, Lordship.
And lose revenue.
I don't know that proposition. Heard Mr. M.K. Chaudhary, senior counsel, listed by Mr. T. Chakraborty, learned counsel for the petitioner. Mr. P. Sharma, land standing counsel, some fisheries development corporation. Within bracket FDC limited for the respond number 1 and 2. And Mr. G. Bokolia, learned junior government advocate, Assam for the respond number 3 and 4. Full stop. The petitioner, the petition hearing has approached this court for the second time after approaching the court by a previous writ petition, WBC number 869/2026, which was disposed of by an order dated 18/2/2026 with certain directions. Full stop. The background specs which led the petitioner to approach the court were mentioned in the order dated 18/2/2026. Full stop. For the writ petition, in view of the nature of grievance raised in this writ petition, in the present writ petition, the same is taken up for final consideration at the motion stage itself, as agreed to by the learned counsel for the parties. Full stop. For the purpose of consideration of the issue raised in the present writ petition, a brief narration of the facts appears necessary. Stop. Para. The subject matter is a fishery named Doloni Fishery, located in Bongaigaon district. The fishery for short, huh? And the fishery is being settled from time to time by the respondent AFDC Limited by way of tender process. First of all, provide a notice inviting tender NIT number 01/2018 dated 25/8/2018, tenders were invited from eligible bidders for settlement of the fishery stating that the fishery will be settled for a period of 7 years post-op. In the tender process, the petitioner emerged as the highest valid bidder post-op. Contrary to the period of settlement mentioned in the NIT dated 25/5/2018, the fishery was settled with the petitioner initially for a period of 6 years only, with the condition that the extension the condition that the settlement for the 7th year would be considered at a later stage post-op. In the year 2019, the position of the fishery was handed over to the petitioner post-op. Subsequently, the period of settlement of the fishery was extended for the 7th year by an order dated 26/6/2025 until 31/3/2026, after the petition had approached this court by way of petition. WBC number 1728/2025, seeking is entirely a direction to the respondent AFDC Limited to extend the period of settlement beyond 6 years. Post-op. Para. It is found to be a consistent stand of the petitioner that as against the position made by the respondent AFDC Limited in the NIT dated 25/5/2018 that the fishery comprised of an area of 867 hectares within bracket land and 300 hectares within bracket water. The petitioner was handed over a lesser area for fishing as a huge portion of the fishery, covering about 25%, was under encroachment post-op. It was only in 2000 January 2026, the say 25% area of the fishery was made free from encroachment post-op. Projecting that the petitioner suffered huge loss in running the fishery during COVID-19 pandemic period and due to lesser area available for fishing, the petitioner submitted a representation on 9/2/2026 before the respondent number 2 seeking settlement, seeking extension of the settlement beyond a period of 7 years post-op. As the period of settlement as at the time of filing a representation on 9/2/2026, seeking extension of the settlement period, which was going to expire on 31/3/2026, comma, an NIT, a notice inviting tender for the settlement of the fishery had already been published on 3/2/2026. The petitioner, having an apprehension that his representation for extension would not be given consideration in view of publication of the NIT on 3/2/2026, approached the court by the writ petition WBC number 869/2026. Full stop. Para. When the writ petition was taken up for consideration on 8/2/2026, comma, this court, after hearing the parties and taking into consideration the facts projected, comma, dispose of the writ petition. With a direction to the respondent number 2 to take the representation of the petitioner, comma, submitted on 9/2/2026, comma, on board, and to dispose of the representation after giving an opportunity of personal hearing to the petitioner by a speaking order as expeditiously as possible. First off, it was further observed that the tender process initiated by the tender notice dated 3/2/2026 for settlement of fishery shall not be finalized till the passing of the speaking order, and the matter of settlement of the fishery pursuant to the tender notice dated 3/2/2026 shall abide by the decision taken in the speaking order. First of para. In purported compliance of the direction to pass the speaking order in terms of the direction made in the order dated 18/2/2026, the respondent number 2 has passed an order on 10/3/2026. First of in this repetition, SL is made to the order dated 10/3/2026 on the ground that the order is not in compliance of the direction made in the order dated 18/2/2026. First of para, for ready reference, comma, the order dated 10/3/2026 is extracted in below page 79. Para. the last senior counsel for the petitioner has submitted that the order dated 10/3/2026 cannot be termed as a speaking order. Also, Mr. Sharma, standing counsel AFDC, has come on the other hand, has submitted that the period of settlement is to be strictly in terms of the contract agreement and the tender notice. Whereafter the settlement officially has been made. He has further referred to the decision of the full bench of this court in number Messrs. 129 Horia Dhablong so and so versus AFDC. PIR 2000 is go 139. GL order signing. Full stop. Para. On reversal of the order dated 10/3/2026, it is noticed that the representation dated 9/2/2026 the grievances raised by the petitioner in the representation dated 9/2/2026 have been answered in the negative by merely stating that there will be potential adverse impact on revenue of the corporation and the same is not tenable in law. Post up. Para. The same. For having considered the contents of the order dated 10/3/2023, it cannot be said that the order is a speaking order, post up, in terms of the direction made in the order dated 18/2/2000. Post up. A speaking order is one which expressly states the reasons for the decision. Full stop. In other words, a speaking order speaks for itself by assigning the reasons behind the conclusion. Full stop. If an order is passed without giving a reason by the concerned authority, then the order is a non-speaking one, which does not provide a clear reason for its decision. Full stop. An authority where the power, authority, and jurisdiction to decide either in the necessity for extension of the period of settlement or otherwise, and similarly, for remission or to allow a request for remission or otherwise, like the response number 2. must record the regions. First of, it is implicit in the principles of natural justice and fair play that an authority which has been vested with such power should record regions as it is part of fair procedure, more particularly when the decision is likely to affect the person concerned. Full stop. The obligation to record regions is a possible check against arbitrary action on the part of the authority invested with the power, authority, and jurisdiction to take a decision which is likely to affect the right of the person concerned, right interest of the person concerned, and to amplify that there is due application of mind from his end. Full stop. Para. In Horia, the Messrs 29 Horia Daplong, so and so Supra, a fullness of this court has clearly observed that the AFDC has been found to have powers to make settlement in respect of the fisheries vested with them as the aims. They have implied power to pass orders regarding extension of the settlement. Most of the full bench has observed that the extension of fisheries the observation has been made by the full court. Being conscious of the fact that extension of fisheries creates unnecessary problems, also create hurdles, and it is for the authorities in the AFDC to find out, to give relief to a settlement holder in proper and suitable cases. Full stop. Para. As taking cue from the observation made by the fullness in so and so, and having reached a finding that the order dated 2026 is not a speaking order, and evidently a non-speaking order, which is not in deference to the direction made in the order dated 18/2/2026. The same is set aside. Also, with the setting aside of the order dated 18/2/2023. This repetition. No, sorry, the respondent of number 2 shall have to consider the representation dated 9/2/2026 aforesaid to pass a speaking order. First up, the repetition is therefore disposed of with the direction to the respondent number 2 to pass is speaking order on the representation dated 9/2/2026. Full stop. The speaking order is to pass as expeditiously as possible. And the order to be passed, speaking order to be passed, shall also be communicated immediately thereafter to the petitioner. Full stop. As the period of settlement of the petitioner is going to expire today, comma, and it is submitted and that the tender process initiated by the tender notice dated
From 3/2/2026.
3/2/2026 is yet to be finalized in the form of a settlement order, comma, the respondent authority, the competent authority in the AFDC Limited shall take a conscious decision as regards operation of the fishery in the interregnum so as to keeping the interest of revenue in mind. First of the matter of finalization of the tender process initiated by the tender notice dated 3/2.
Yes.
3/2?
Yes.
What?
3/2, yes.
3/2/2026 shall abide by the decision taken in the speaking order to be passed.
My lord, pursuant to your lordship's order, we file another representation at page 76, dated 23/2/2026. That
Okay,
also, both the my lord represented.
Represented so and so, and a representation, comma, filed subsequently. A representation, comma, stated to have been submitted on
23rd of February 2026.
comma.
Yes, Lordship. If it's,
I'm not saying anything.
if not, but yes, yes.
To whom take a conscious decision so as not to lose the revenue, keeping the interest of revenue,
That's it.
and to operate the fishery. It is up to you. If it is barred by law, barred by law. Conscious decision means as per law, take a decision.
Lots.
Maybe ad hoc. Maybe ad hoc.
No, we cannot give lots. That
It
is
is up to you. I am not saying anything.
Highly obliged.
You may convince.
Lots.
Production list, promotion. Item number 2. WBC 1912 of 26. Production list.
Just a minute, Mr. Sharma.
Yes.
Yes.
My lord, the impugned letter is in page 106, my lord, annexure I. This is a termination notice dated 13/3/2026.
This on which part respondent?
My lord, there's no respondents, my lord. There's
IOC does not have.
no, my lord.
Huh?
We tried to serve them copy, but was told informed that there are no standing councils for IOC. For Bongaigaon refinery.
This is under IOC only.
My lord.
The IOC, I think they have a standing council.
No, my lord.
No, Mr.
IOCL has, but Bongaigaon refinery doesn't have.
Mr. M. Sharma, he used to appear as a standing counsel.
My lord.
Mr. M. Sharma.
No, what I have gathered is, my lord, that they are distributed based on a case-to-case basis. There's no
I don't know, but when I asked, he said standing counsel, so I recorded it as standing counsel. Okay. Yes.
At 106, my lord, is a termination letter. Now, my lord, I am a subcontractor of respondent number 5. Permission was granted by the respondents for us to be a subcontractor for operating ambulance services on behalf of the IOCL.
Where is that? Where is that?
Page 60, my lord.
Yes.
Now, at page 60, after granting us a permission to operate as subcontractors for operation of for running the ambulances on behalf of the respondents, now they have stopped making us payments at page 52. No, at page 52, it will be clear to my lord. The terms, this is a contract. Parties to the agreement, if your lordship comes to the middle portion, parties to the agreement at page 52. This is a contract. So given life, the buyer is responsible to provide clear instructions, approvals, and timely payments for the services availed. Now, they have not given us the payments. They've stopped making us the payments and irregular payments. They, for a month of November, they paid in March. So we could not disburse salaries to the contract workers working under us. That is the only grievance. We are paying salaries, but not on time due to the non-payment of the respondents. And they are bound by contract, they are bound to pay us every month, the RA bills. They haven't done it. Now, at page 15 of my petition is the table. If my lord has it, this is the for the month and salary paid on. We have paid the salaries, and the second table is a bill period disbursement. Disbursement is the late payments made by the respondents to us, so withholding our bills for no reason at all, no apparent reason at all. And they've imposed penalty of 3,000 and 75,000. Now, in my case, my lord, after the 13-3 letter terminating our services, additionally, they have imposed a fine of 75,000 also. That is the my lord dual.
Where is the termination?
My lord.
Where is the termination? Order?
105. 106, my lord. NHRI. They've cancelled the subcontract.
This has been issued on 13/3.
13/3, my lord. Then
Ah.
after that, at 107, my lord, at page 107 is a representation against this termination order to the Deputy General Manager, Engineer in charge.
But main underlying contract hasn't been terminated.
No, my lord.
Hmm.
That is of the respondent
They have
number
been
5.
asked to make alternative arrangement.
My lord. My lord.
So it is your
It has-
termination as a
it has affected-
subcontractor only,
It has affected my livelihood, my lord.
right?
And without any apparent reason, the only at 106, your lordship will find only apparent reason is there is several instances of non-payment of contract worker salary on time, including the month of February 26. Now, my lord, December salary RA bills they are submitting, giving us in March. Even then, we are trying to make not timely payments, but we're making payments. There's no complaint from any quarter.
But main contract is not terminated,
But I'm the affected party, my lord.
right? But so far as main contract with the principal contractor
My lord.
has not been terminated, they have been asked to make alternative arrangement.
My lord, and my lord, but as far as I am concerned, my lord, as per my submission, my lord, I have invested money and
Yes.
workforce for this contract, my lord. The subcontract is for 3 years, my lord, period of 3 years, my lord. Now, a businessman like me, my lord, where will I go after this? At 106, my lord, and the last para, hence the permission of subcontract is cancelled with effect on 31/3/2026, and you are requested to make alternative arrangements.
So there is no tenure for subcontract.
At page 36 of the contract, madam.
No, that is with the principal
With
contract,
the principal contract,
not with you.
not with me, because
You entered the scene subsequently. Where is the main contract?
permission of contract. Where is the permission?
Where is the main contract?
I'll with respondent number 5, because respondent number 5 is the person who is allotted with the subcontract after the permission. At page 51, my lord, contract. Permission the letter from permission letter. At page 60, my lord. This is the permission of the IOC. IOCL permission for subcontract of the WO dated so as per later dated so and so. Page 60.
Oh, that is subcontract.
Subcontract. That is a
But
permission given by the respondent.
Permission is granted,
Granted.
but where is the main contract?
Page 51, my.
That is bid document perhaps.
Bid document.
That is bid document.
At page 44 is the letter of acceptance. Page 44. No show cause has been given to me. No, there's no show cause.
No,
actually.
it is main contract is with
With respondent number 5, my lord.
respondent number 5,
Respondent number
not with you.
Not with me.
So they don't want the subcontract service. They have withdrawn it. But
No.
my main underlying contract hasn't been terminated yet.
My lord, with all respect, my lord,
Right,
it cannot be arbitrary, my lord. There has to be a show cause notice. They have to give us notice. We have the right to be heard before.
I don't know whether you have a right to be heard or not.
At least the main contractor, the respondent number 5 has to be heard.
Yes,
Even that is
he
not
will
done.
espouse the cause.
Even that is not done, my lord. There's no.
No, that contract has not been terminated. See the word. Who is this? You are what?
I'm Devi Enterprise.
This is both the communication has been
Addressed to
issued.
respondent number 5.
Respondent number 5,
My-
not to you.
My lord.
Not to you.
My lord,
There is no direct
my lord, let the
privity
respondent,
of contract.
my lord is very correct. Let the respondent number 5 and
He has allowed you. They have not entered into a tripartite agreement. The IOC or BRPL has
My-
allowed the respondent of 5 to bring in a subcontractor.
subcontractor.
Right.
My lord.
That is you.
My lord. But as per the letter, my lord, indirectly.
And thereafter, by the impugn order, they have said, we are not letting this subcontractor
My lord,
to
by-
perform the job.
My lord, with all respect, by implication, the privity of contract comes in, my lord, between the respondents
That
and
needs to
me.
be examined, but we cannot allow at this stage.
At
We
page
cannot
50
allow reinstatement at this stage. It is the best way is to seek damages.
My lord, kindly come to page 56, my lord. This is a kickoff meeting. I am at this is MS Devi, this 56, my lord, page 56. This is the minutes of the meeting. MS Devi Enterprise is authorized to execute so and so, or submitted by MS LifeJet Cardiac Service. On 3rd July, a kickoff meeting was held in the office of EIC Shri Akash Potim Borua in the presence of so and so with so and so of Devi Enterprise to facilitate an overall process of the contract. The following points are discussed and agreed upon in addition to terms and conditions of the WO dated so and so. Initially, 3 numbers of ambulance will be engaged temporarily.
And what are the in-between communication?
But there's no communication. They have not informed us anything, no show cause, nothing. And my lord, at page 57, Sanjeev Kumar Bharti is respondent number 5. Asif Hussain is the respondent number 1 to 4. Akash Potim Borua is respondent number 1 to 4, my lord.
This is merely a subcontract.
My lord may examine the matter, but my lord may have it next week also, but until today is the last day, my lord. And it was such that 13-3 they issue the termination notice, then
It
again.
is not that the contractor is also selling with you. The communication is made to the contractor, not to you.
Yes, the contractor had filed a representation, my lord.
Maybe.
My lord. My lord may examine the matter, my lord may give 1 week. Protect me for warning next Wednesday.
No, we cannot reinstate the contract. This is a subcontract. This is a subcontract. Both the communications are addressed to the main contractor. The 36/2025, that is page 60, and page 106 also. They are not satisfied with the subcontractor. Ultimately, the responsibility to deposit will decide about that. Subcontractor, your rights are limited.
My rights are limited, but the action, what I'm on is, my lord, is that
Because
action is
of the
arbitrary.
fact that the underlying contract with the principal contractor has not been terminated.
My lord.
They have chucked out the subcontractor and asked the contractor, bring in another.
My lord, in the meantime, my lord, another writ petition is pending by the main contractor for totally, my lord, causing the credentials of the main contractor. They are also before this court, my lord, arising out of the same contract, my lord. But our rights, my lord, my submission is that this has been done arbitrarily without issuing a show cause to the main contractor also, to me also. And it is because of their laches that they have not paid us.
Let the parties come, let the parties come.
My lord.
We cannot rescind the contract at this stage. That too subcontractor.
Why don't we hear the parties, man?
Yes, definitely we will hear the parties. If they have erred, then definitely.
My lord.
Heard Mr. R. Sharma, Land Senior Counsel, hosted by Mr. D. Deka, Land Counsel for the petitioner, post of the petitioner has approached this court agreed by an order of cancellation dated 13/3/2025, addressed to the respondent number
5.
5. Full stop. Whereas the case of the petitioner is that the respondent number 5 was awarded in work order dated 20/05/2025. For the contract work of hiring and operation of 3 ALS ambulance services at Bongaigaon Refinery Hospital, Dhaligaon. Full stop. As per the work order, the contract period is 3 years and the contract value is 4,35,57,452. Full stop. During the course of the contract, the employer, IOCL Limited, permitted by a communication by an order dated 36/2025, permitted the respondent 5 to let the petitioner to perform the job of providing providing the services as per the terms and conditions of the work order dated 20/05/2025. As mentioned in the general conditions of contract within bracket subcontract, subject to fulfillment of the conditions laid down therein. Full stop. But all on a sudden, on 13/3/2026, the petitioner has contended that all on a sudden, 13/3/2026, by the impugn order addressed to respondent number 5, the respondent IOCL authorities have cancelled the permission of subcontract with effect from 31/3/2026. Full stop. Mr. Sharma and senior counsel appearing for the petition has submitted that in the impugn cancellation order, the respondent IOCL authorities have cited several instances of non-payment of contract worker salary on time, including for the month of February 2026, which had to be paid directly to the contract workers. Full stop. It is his contention that it is the delay to release the dues all throughout the contract period were attributable to the respondent IOCL authorities, and as such, the grounds attributable to the authorities in the IOCL as alluded in paragraph 5 of the petition, therefore, the allegation made regarding delayed disbursement of wages to the workers of the petition and the respondent number 5 is without basis. Full stop. The matter would require consideration. Full stop. The let notice be issued. Notice is made returnable on April or did you?
April.
You take steps on all. Dusty?
What?
Yes, speed post. Within 2 working days. You appear for somebody. Okay, Miss R. Dave. On behalf of SS Roy, CGC. Respondent number 1. Then 225 by speed post. Within 2 working days. In addition, as paid for Dusty compliance affidavit. Other before the returnable date. The prayer for interim relief is kept open for consideration on the return date.
My lord, it will become infractious, my lord. My lord may fix a short date. On that
Short date we can do only after Bihu.
My lord, 27th April, my lord.
I have said.
After that, if my lord doesn't find any merit, I go, my lord. I have no case then. If I
main contract is still there.
no, my lord, it will be on my part. It will be infraction. It will be difficult.
No, if Mr. Sharma, if I consider your interim prayer, perhaps it would be to your detriment.
My lord, due to balance of convenience, my lord. It is a very.
I have indicated, so I have kept it open
My lord,
for the benefit of the petitioner.
My lord, for this businessman of my stature, my lord, may kindly protect me for this month, my lord. 3 weeks, my lord.
No, I cannot revive the contract.
No, my lord, that is a
You
separate.
cannot revive the contract. How can I revive the contract? I cannot write the contract, rewrite the contract.
But until the returnable date, my lord, I may be protected only then, only as an interim
What
measure.
kind of protection?
My lord, that
Principal employer, contractor is still there.
is still there, but I'm gone, my lord, and all my resources, all my gatherings, my loans, everything is gone, my lord. On one single day, that is today, my lord. So, my
You
lord,
can only observe that no further adverse action should be taken. It is observed in the interim that the respondent authorities, respondent IOC authorities shall not take any further adverse action against the petitioner on the basis of the impugned order of cancellation dated so and so, 13/2026.
2704.
obliged, my lord.
For impeachment of party, item number 11.
Yes, sir.
My pleasure, Lord.
Whom do you want to include? Which one?
Lordship, Faisal Mahmood Siddiq.
Okay. Heard. Anybody appearing in the main case?
No, quite there.
He is not there. Heard. Mr. M. Bosumati, Learned Counsel for the applicant. Full stop. The instant interlocutory application is preferred. Seeking implement of the following authority. As party respond number 3 in the accompanying contempt petition, contempt case C number 205/2025. Full Para, the applicant as the petitioner has preferred the accompanying contempt petition, contempt case number so and so, alleging non-compliance of the direction made in an order dated 6/10/2020. Passed in a petition WPC number 7353/2018. By the order dated 6/10/2020, a direction has been made to the Chief Engineer Irrigation Department to release the dues of the petitioner admitted amounting to rupees 57,91,047 within a period of 4 months, as the said direction was not complied with, the contempt petition was preferred. First of para, it is averred that during the pendency of the contempt petition, the incumbent holding the post of Chief Engineer, Irrigation Department, Government of Assam, i.e. the respondent, party respondent number 2 has been transferred from the said office, and in his place, the proposed party respondent has joined joined as the Chief Engineer, Irrigation Department, Government of Assam. Also, in view of such subsequent developments, the instant interlocutory application is preferred. Post of, as the proposed party respondent is presently holding the post of Chief Engineer, Irrigation Department, Government of Assam, the instant interlocutory application seeking his replacement as party respondent number 3 in the accompanying contempt petition is allowed. First up, the learned counsel for the applicant shall file an amended cause title in terms of notification number so and so within a period of 3 days, and on submission of such amended cause title, the registry to carry out the necessary correction in the cause title in the accompanying contempt petition as well as in the CAS first. The accompanying contempt petition is to be listed on so and so.
1305. Part matter, item number 12.
এইটো কি আৰু এটা যে আইনে কিবা আহিছিল এইটো কি এইটো চিন আৰু মাইকেল এইটো কি 13 ওকে এইটো কাৰ মিস্টাৰ গোস্বামী Yes, Mr. Goswami, you have an impleadment application in your case.
You have seen that.
Oh,
So we would like.
I don't know. I have just informed you.
Yes, yes, sir. We have been served.
Who is he?
We really, he is my partner
Oh, that.
who has no privity of contract. At this stage, when he jumps into the fray, say that I am a proper party or necessary, we can demonstrate if lordships, wherever
Okay,
chance comes,
Okay,
he has no privity of contract.
okay. You are for that?
Yes. Lordship is taking up 30.
No, this one, the other partner. We'll record the facts and submissions. If you hand over the records,
sir.
then we'll pass the order after going through the records, right?
Very well.
Because we have to rise early. Because of reference, perhaps. Okay, Mr. Khoniger, what is your prayer here? Have you marked the pages?
Yes, the mark page is empty, Your Lordship.
Invoking the extraordinary and discretionary jurisdiction of this court under Article 226 of the Constitution. The petitioner has preferred the instant writ petition to assail. Have you not challenged the award?
No.
He's not challenged that. He's just asking for interim for the allotment of license.
I absolutely.
At that point of time, that was not allotted, madam.
But that has been brought to your notice,
No, that,
is it not?
no, madam.
Huh?
But that was not within my knowledge, madam.
How can it be?
Page 24, madam. Can I have a look, madam? That is only recommended. According to Honorable Gazetteer Officer, recommended the application of IMFS of Suna in
Is-
favor of
One
Navdeep
minute.
Sharma.
Page
Page
number 11 of my IM, that is the section from the.
Sanction order was brought to your knowledge. That is 12/9/2023. Part of IA. And with that, I think they sought vacation of the interim order.
Only that.
1 minute, let me see it, let me see. Subject to outcome of the repetition. Subject to outcome of the repetition. Tony license is subject to the outcome of the repetition.
That
You
was
can
all.
proceed. As approach this court. No, as the repetition has been preferred. For a direction to the respondent authorities in the Excise Department, Government of Assam, to complete the process of issuance of retail Indian-made foreign liquor within bracket IMFL, quote unquote, off license for Sinai area of Silchar Kachar, district Kachar, in compliance with the terms and conditions laid down in a public notice bearing number CXE 0.09/2017. 194. Dated. What is the date? (25/10/2021). In a fair and transparent manner and strictly in terms of the provisions of the Assam Excise Act 2016 as amended and Assam Excise Rules also 2016,
2016.
as amended. Para. The genesis of the lease is made relatable to a public notice. The public is a notice hearing number CXC 0.09/2017/194. Dated 25/10/2021. Issued under the hand of the respondent number 3. And the notice was published in published in widely in daily newspapers. White Zono Songjok stroke D stroke 9489 stroke 2021. Poster. By the notice, comma, applications were invited from interested and intending eligible persons in the prescribed format for issuance of fresh retail IMFL of licenses at 2 places, namely 1 Tholai and 2 Sonai. In the district of Kachar, Assam. Post op. The applicants were directed to submit the applications in a prescribed format with all the relevant particulars as applicable under the provisions of the Assam Excise Rules 2016, and the applications were to be submitted in the excise branch of the District Commissioner's Office, Silchar Kachar, by 26/11/2021. It was specified that the proposed sites shall be as per the required specifications, and the sites should not be located within the specified distance limit of educational and religious institutions, hospitals, and national highways. So stop. In response to the notice, the petitioner, being an inhabitant of Silsor town, submitted his application for retail IMF shop license for the advertised area, Tonai at Silsor with all the relevant documents. As per the terms and conditions laid down in a notice and in conformity with the checklist as checklist contained in the prescribed format prepared by the Excise Branch Office of the District Commissioner, Kachar, Posto. Where? It is the case of the petitioner that he came to learn that another applicant, that is the respondent of 5, had also submitted his application for the license at Sonai area. Postal. What is your ground of objection? Mr. Khanikar?
That was recommended by on the recommendation of the guardian, Mr. Whole thing has been done, my lord. On the recommendations of the guardian.
No, that is not a case set up in the writ petition.
Huh?
What is your ground? What is your objection? Okay. Okay. When the petitioner came to learn that the office of the respondent, office of the district commissioner, Kachar, forwarded forwarded the application of the respondent of 5. For approval to the higher authorities. Now petitioner submitted an objection before the respondent number 2. On 29/6/2022, as the respondent number 2 is the licensing authority for issuance of IMFL of licenses under the provisions of the Assam Excise Act 2016. As amended. When the objection dated 29/6/2022 submitted for taking necessary steps not to allow the respondent of 5, not to allow the license not to allow the IMFL of license in Sona area to the respond number 5 did not evoke any response, the petitioner submitted an application under the Right to Information Act 2005 RTA Act for short before the respond number 2 on 21/7/2022 seeking status of his application for the IMFL soft license as Sonai submitted pursuant to the notice dated so and so post of or in response to the application party application or a petitioner, the PIO, sorry, the respond number 4 responded, provided the reply, provided an office letter, provided the information under the RTA Act, provided an office letter number page 26 dated 17/8/2022. Postal. Para. In the information provided on 17/8/2022, it was mentioned that the application of a petitioner and 2 other applications were forwarded to the what is PS? Private Secretary, or personal, to the Secretary, to the Guardian Minister, Kachar District, Dispur, provide an office letter dated 14/12/2021 as per a government letter bearing number EX 145/2017/82 dated 25/10/2021 for appraisal and necessary approval of the Guardian Minister. Post up. It was further mentioned that the Guardian Minister had recommended the application of the respondent number 5 for the IMFL of license shop at Sonai, White, an office letter number MIN, dated page 25, 6 or dated 6/1/2022. Post up. Agree by the recommendation made by the Guardian Minister in favor of the respondent number 5, the petitioner has preferred the instant petition. Post up. Para. When the writ petition was moved on June 9, 2022, the court, while issuing notice to the respondents, also heard on the prayer for interim relief. First up, it was observed in the interim, it was observed that issuance of any license in favor of the respondent number 5 will be subject to the outcome of the writ petition. First of during the pendency of the writ petition, comma, the state government in the excise department on 12/9/2023 accorded sanction of for IMFL of sub license in favor of the respondent of 5 and the said decision was conveyed to the respondent number 2 by an office letter bearing number 227285/135 dated 12/9/2023. After such sanction, comma, he was originally implemented in a writ petition. The respondent number 5 moved an application, interlocutory application, comma, IAC number 3359/2023. Seeking a direction to the respondents to issue the IMFL of license to him pursuant to the sanction granted on so and so by the state government and or for an appropriate order on that basis. Full stop. The interlocutory application ISC number so and so was taken up for consideration on 7/2/2024. Full stop. After hearing the Senate Council for the parties and taking note of the interim order, taking note of the observations made in the order dated 2/9/2024, comma, the court in its order dated 7/2/2024, while disposing of the interlocutory application, I had observed that there will be no impediment for the respondent authorities to issue the license to the applicant as respondent number 5, comma, as the same in any event, comma, would be subject to the outcome of the writ petition. First. Para. On the basis of subsequent to the order, it is 7/2/2024. License has been granted to you? Where have you brought? Okay. It's stated that subsequent to grant of section on so and so. And the order dated 7/2/2024, the respondent number 4 has been issued the IMFL shop license for the Sona area. And as on date, the respondent number 5 is operating an IMFL shop license as Sona area. First of all, para. I have heard Mr. A. Conicor, learned counsel for the petitioner, Mr. R.R. Gogoi, learned standing counsel, excise department, for the respondent number 1. 1 and
Respond number 1 and 4.
4.
4.
Mr. M. Setia, learned junior government advocate, Assam, for the respondent number 2 and 3. 1 minute. You have any amended cost title? Huh?
That was allotment.
Okay. Huh? Also 6.
6. 6 has been included later.
Huh? 6. And Mr. G.N. Sarawala, senior counsel. Except by Mr. H.K. Sharma, learned counsel for the respondent number 5. Full stop. Mr. Gogoi,
Okay.
what are the provisions of the Assam Excise Act?
The rules of 2016, rule 100.
Assam Excise Act, anything?
No, anything, this is not. Rules, it is there, Lordship.
Assam
Excise rules 2016.
Excise
Rules
Rules.
2016. Rule 113.
Rule 113.
It's a grant of excise license, Your Lordship.
Rule 113.
And Rule 114.
114.
That will do it.
And when this new rules have come?
This public, around 2025, Your Lordship.
Do you have anything?
That new notification came on. Seventh of April 2025.
Can you send it to the court master?
Yes, Your Lordship.
7?
7th of April 2025. This regarding this public notice.
113. No, where is the licensing authority?
114. It comes 114.
100?
2.
114.
114. Subclause 2.
Subclause?
2.
2.
Grant of retail sale of foreign on of premises.
Paint the police piece of
Offer price shall be granted by
14.
district collector.
113 or 14?
14. 14.
14.
Yes. Clause 2. Grant of retail license of foreign liquor on or off the premises subject to Rule 279 of the rules. License for retail sale of foreign liquor off or on premise shall be granted by district collector with the previous sanction of the state government.
Is there anything on sanction?
Sanction. At 1 year loss. License for wholesale brand foreign liquor shall be granted by the excise commissioner with previous sanction of state government on payment of annual renewal fees as prescribed state government from time to time.
Sanction, the word sanction is appearing only in here.
In here.
Nowhere else. And is there any definition?
Sanction.
Definition. Creating there is nothing in the act or what?
Yes, the act has only definition of the district collector, Your Lordship.
Definition of district
District
collector.
collector is there in the act.
And in the rules,
In the rules, there's no definition of it.
no definition.
No definition. But the definition of collector, district collector is there. The Assam Excise Act 2000, Your Lordship. Page 2. D and G.
Mrito Sanjeevi is also included in the rules. Okay. So I go by you. 113 and 14.
113, 14. 113 is a chart where he has to pay, and 14 is how the license is granted. How the license is granted by the district collector. If
How the license is to be granted.
how the license will be granted, Your Lordship. And if I may take Your Lordship.
113 is shifting.
No, it's shifting, issuance of shifting, any new licenses there, Your Lordship. All application grant of excise license or shifting of license premises.
Okay. Okay, I'll record
Very well.
your submissions. We'll dispose of after seeing the records
Very well.
as indicated. And what do you say about this consultation and recommendation?
That is, I'll just make fair submission, Lordship. The rule of the guardian minister in the act or in the rule, it's not there. Something is by the state government or district collector. They are
So rule is silent on the minister,
yes.
right? By the SOP
By the SOP, he says consultation.
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 So there cannot be any abdication of the power.
Yes. I'll be completely fair on this one.
So licensing authority, that is the district commissioner.
District collector.
He
the
is a statutory authority to grant the
grant the
license.
license.
And we have seen there are three participants.
3 participants. 1 was a petitioner, 2 were there.
And a third one,
Official.
third one also. So there was no final decision on the comparative statement as
It was not
regards suitability of any one of them. And thereafter, that
From the records, it's clearly seen that even the third person is clear of everything.
he was also clear. It is not that there is no decision that this man is.
He's not. It's not like a bidding process. He's not been qualified or something like
It
that.
is not that he is a disqualified one.
Yes.
So before that letter came. Will dispose of. By
The
tomorrow.
records will be kept in Lordship.
Records. Mr. Goswami, actually sorry for early rising
Yes, so there's a.
due to reference.
Instructing counsel, that's a sheer coincidence wherever our this matter is listed as a reference.
Oh,
So last time also there was a reference, Lordship had reason earlier. Anyway,
Actually, it has been in a official decision that last day in a month would be the date of reference.
for everyone.
So
No,
for
that's
your
okay.
knowledge, So next time, don't take the
No, no,
last date in a month.
no, that's okay. Someone may not even die the whole month. It can also happen. So let's also not assume that
Yes.
somebody will die every month.
Yes.
But
I've been told that in one particular high court, they don't work on last working day.
that's then, I know that it's not possible to take up this matter today,
Uh,
but I was just wondering if it is convenient to your lordship's court. Now that I'm here physically, can it be taken up tomorrow, lordships?
Tomorrow again, a list of 60. We can
At 2
have it
o'clock?
on day after tomorrow. That is the
In that case, I'll,
maximum we can do.
but in that case, lordship will keep it at 2 o'clock.
I don't fix as soon as
Whatever it's done.
that is also a convention. Mr. Gautam knows. Even if it is 3:34, I'll take up if I decide to take up.
That is done.
Day after tomorrow. And what do you say about his application?
Yes, if lordship will kindly see the application itself.
It appears to be more bulky than the writ petition.
Yes, yes.
Yes, there are many documents that needs to be.
In fact, whatever has been stated here is already stated in the writ petition and in the writ petition about
That
That will, whether Mr. Borua, you have submitted your affidavit.
Yes, yes.
And that will serve, if I allow you, that will serve as an affidavit for you.
And Lordship, then I need to bring additional documents, Your Lordship, because I have invested in this partnership. Around 92 lakhs. They were supposed to pay me
Lordships,
1 crore.
may I just-
57
No, we are on the decision of the ONGC. How-
Yes, yes.
Decision of the ONGC, Your Lordship.
That will be a matter of damage
Yes.
or compensation.
No, Your Lordship will see page 18 of my.
But we are in the nick of time. Okay, we
I will
will
say-
hear both of you on Thursday.
Yeah, I'll satisfy you. In fact, the sole proprietorship
It
doesn't
will be
exist.
inconvenient for you Thursday. Okay, I'll accommodate you.
Who will see?
The court will accommodate you.
This sole proprietorship has been converted to a partnership.
Ultimately, what lordship will have to see, well, whether lordship will rewrite the contract. The contract is privity is between whom and who is he? He's my erstwhile partner. Who is the partnership deed is dissolved?
No, it's not dissolved, Your Lordship. It's a registered partnership deed where the presumption will be drawn on the registered document. And secondly, Your Lordship, the sole proprietorship does not exist as of today. We have stepped into it. That has been converted to the partnership, Your Lordship.
Okay, heard Mr. M. Goswami, Land Senior Counsel, stated by Mr. D. Gogoi, Land Counsel for the petitioner, and Mr. P. Bora, Land Counsel for the respondent, 1 and 2 are present. First up, release the case on so and so. Due to paucity of time, due to early rising of the court or the reference, the case could not be taken up today. Release the case on as sought for and agreed to by Land Counsel for the parties. Release the case on Thursday. তাৰপিছত লিখিব আইত লিখিব R. Sharma, Land Counsel for the applicant is present. Release the case on Thursday.
Good.
We're not passing any order in the IA today.
Oblige, Your Lordship.
Item number 15, there's an interim order, Your Lordship.
Any?
In item number 15, Lordship, there's an interim order, Lordship.
Item number 15.
Lordship, that-
What is this? Oh, item number 15.
Regarding Lordship, right of fishing rights, Your Lordship, over VGR land, Your Lordship.
We're not passing any order.
Lordship.
So it will come
Lordship,
automatically.
Lordship,
Right?
Lordship,
It will remain.
Lordship.
Great.